Good evening, everybody. Daniel Sherman here. I'm about ready to go to bed. I thought I would make a video. I promised you guys I'd make a video on the violent offender statute and kind of tell you what that is and what it means. So the violent offender statute designates certain offenses in Kentucky as violent offenses, and those have certain impacts on your ability to be released and your ability to receive good time and to be probated and to receive parole. So the list of violent offenses are contained in KRS 439. Those are going to be, not an exhaustive list. Any Class A felony, murder, any capital offense, any offense involving serious death or serious physical injury to an individual. So that now includes assault second degree, which it didn't previously. Criminal abuse in the first degree, robbery in the first degree, basically any sex offense. That also includes unlawful transaction of a minor in the first degree, which is a Class C felony. It's going to also include now wanton endangerment when there's discharge of a firearm. And again, basically any sex offense. So those are going to be, your violent offenses. Now, what is the effect of a violent offense? The effect is you are not eligible for parole until you serve at least 85% of your sentence. So if you receive a 20-year sentence, you have to serve, 17 and a half years before being eligible for parole. Additionally, you do not get any good time, you do not get any work credit, you do not get any program credit. So the way it works is your minimum expiration date, which was I explained before in a prior video, is the exact same as your maximum expiration date. That won't change. The only credit you are able to get is the credit you spent in custody prior to being sentenced. All the other credit you are just unable to get. So if you do have a violent offense, you're going to be serving, quite a bit of time. Even now, if you get convicted of some of the sex offense D felonies, then you're going to serve it out, but you're not going to quite do as much time. But most of these are C and B felonies. I will say this: even if the maximum sentence you can receive in Kentucky is either life or 70 years if everything is stacked. That's the most you can receive as far as years are concerned. You have to be eligible for parole after 20 years. So unless it's a capital offense involving where you're, sentenced to death or life without parole until 25 years served, no matter how many years you get, whether it's 70, 100, 5 million, you are eligible for parole after 20 years. That is the longest they can hold you until considering you for parole. But as you might expect, parole is something that it's not guaranteed. And a lot of times on these cases, if you've committed a violent offense, there's usually a victim on the other end. And my experience is if those victims write the parole board, it's really difficult to get released. Even if they stop writing. I had a case, we had helped this guy and we're looking at the case. It was out of Christian County. It was a murder case, and we couldn't really find anything that really would help his case, but we ended up talking to the victims' families, and they kind of willing to let bygones be bygones, and they stopped writing the parole board, and they said, we're okay if he gets paroled, and parole didn't parole him anyway. So I think he's actually still serving. So it's the way parole works, especially with violent offenses, they're tough to be released on parole. So a lot of these you're going to be serving out. So when I represent clients, I've got to let them know that. So that's violent offenses, and that's kind of the problems with it. There's a couple other offenses I want to talk about today. I want to talk about the 50% parole eligibility. So the new fleeing and evading statutes, fleeing evading first and fleeing evading second. And if you look at my preliminary hearing tape, I kind of break down what that is. Those are now 50% parole eligibility and probation. And the reason they put probation in there is because, for instance, if you received a sentence of, like on second-degree felony evading 1 year, and you served 6 months prior to being sentenced, well, the court can probate you because you've served half the time. So that would be when probation would, be available to an individual on a fleeing and evading charge. Also, trafficking fentanyl is, and that's been for a few years now. The Class C felony version is a 50% parole eligibility. So those are kind of half violent offenses, but those are at least certainly the fleeing and evading is a new one, and that catches a lot of people because you get a lot of people that don't want to stop when they're getting pulled over, especially if they're on drugs or they're high and they're just not thinking right, and they think, well, I can outrun the cops. And I think I told you in prior video, I had a guy who was on a really slow speed chase. He was going the speed limit. He drove for like 40 miles. That's fleeing. That's a 50% parole eligibility, and so you have to understand that. I also want to talk a little about the persistent felony offender statute. I have a lot of clients that think they know what it is, and they just kind of really don't get it. So to be a persistent felony offender, you have to be convicted of at least one felony, and you have to be at least 18 years old at the time you committed that felony. And then your current felony, you have to be at least 21 years old. And that felony, that prior felony, at least one of the prior felonies, has to be within a 5-year period of the commission of the new felony, or a 5-year period of the serve out on that, or a 5-year period of probation or conditional discharge. So let's just say you get a 5-year sentence, you're probated for 5 years, you complete your probation, 3 years later you pick up another felony, you're a persistent felony offender in the second degree. To be a persistent felony offender in the first degree, you just have to have one of those felonies within that 5-year period, and then one, it doesn't matter if it's 20, 30, 40, 50 years before. You just need the one within the 5, and then, again, obviously you're over the 18 when you committed the offense, and over 21 as you stand charged. And you don't have to be convicted of a persistent felony offender in the second degree. A lot of people say, well, Daniel, I haven't been convicted of PFO 2, how can I be convicted of PFO 1? That's not a requirement. A lot of times people are not convicted of PFO until they get 3 or 4 different felonies. So that's the PFO. Now, what the consequences of that are is it raises it 1 level for PFO 2, and then it raises it 2 levels for PFO 1. So for instance, a Class D felony becomes a Class C felony for PFO 2, and then becomes a Class B felony for PFO 1. So as opposed to 1 to 5, you're 5 to 10 or 10 to 20. Now you can enhance every felony with PFO with the exception of possession of a controlled substance. You cannot enhance that with a PFO. So whether you have 1 or 10 of them, you can't enhance that offense. But you can use possession to enhance another offense. You also run into issues of double enhancement, especially with a DUI. Your DUI fourth offense, you could not use the DUI fourth offense on a prior to enhance it to another DUI fourth and then a PFO. So you really can only use it for one enhancement. I'll also say they changed the statute a few years ago that for trafficking second offense, you can't PFO that. You can either second offense or greater or PFO. You can't have one or the other, and the Commonwealth always chooses the PFO because it enhances more. Now, some of the ramifications are if it is a D felony and you're PFO 2 or PFO 1, you are eligible for probation and you are eligible for parole at 20% parole eligibility. If it's a Class C felony and it's a PFO 2, you're eligible for parole at 20%, but you are not statutorily eligible for probation. Now, courts still probate you. Nobody's really going to jump up and down, especially if the Commonwealth agrees with it. There's no issue there, but the statute does say that if you have a PFO 2 and a Class C felony, you are not statutorily eligible for probation. Now, if you're a Class C felony or higher and you're PFO 1, you are required to serve 10 years prior to being paroled. So if you receive a 20-year sentence on a PFO 1, you're going to be serving 10 years before being paroled. Here's the rub, though. If you get a 10-year sentence and a PFO 1 on a C, while you might only be eligible for parole for 10 years, you're still eligible for your good time. So most of my clients, actually all of them that I've seen, if they get a PFO 1 on a Class C felony, they're serving out in 5 or 6 years, because some of them serve out in 4. They'll do as many credits as they can because they know they got to serve out. So that minimum date can keep coming down. The parole date, though, doesn't change. So it's kind of odd that your minimum date is going to be lower than your parole date, but that's just kind of the way it works. Now, if you get up into the 20 to life ranges, you're 10 to the board, and if you get life, though, I mean, you're 20 to the board. So I mean, they can't, you have to see the board at least at 20. So I mean, if you get those B felonies and you're 20 to life, those can really stack up. And even though they may not be at 85%, it almost becomes an 85% if they give you enough time on it. So just that's kind of the way that works. That's the way the PFO works. That's the way the violent offender works. And then you've got the 50% stuff we've talked about. So just wanted to follow up with my prior video on nonviolent offenses. Now I'm telling you, the parole dates, what they are in violent offenses. And then again, with a violent offense, the minimum dates are the same as the maximum dates, because you don't change. So remember that. Robbery first, you get a 10-year sentence. Minimum, maximum are 10 years. Your parole was 85%. So, at 8.5, you can get parole, but that's, so you can be serving between 8.5 and 10 years. You get a 10-year sentence on robbery first. So that's the way the violent offenses work. That's the way the 50% parole eligibility works. And again, with the 50% parole eligibility and even the PFO 1, 10 to the board, so to speak, you still can get your good credit, and you still can knock those sentences down. So, it's not a life sentence if you get those, but it can be, very difficult to explain to a client, hey, you got 10 years, you're not going to get paroled, you're going to have to serve it out. So, and that certainly happens sometimes. And I guess I'll just say this. There are some counties that will not PFO you unless, you set the case for trial. They'll do a superseding indictment. The hope is to resolve the case. If you don't, they'll kind of put the hammer towards you. I will tell you, most of the counties I practice in Muhlenberg and Hopkins and McLean, they typically will PFO you. I do quite a bit in Christian County, and they won't. Usually they won't, unless you set it for trial. So, PFO really kind of is a bargaining chip, and I've had cases where clients PFO 1, get acquitted, great, and I've had them where they're convicted, and sometimes when my law partner tried a case once, and I couldn't help him try it because I had to be a witness in it, and when the jury heard the sentence they had to give the guy, they actually wrote in a different sentence. They did not want to give the guy 20 years. They wanted to give him 5. And they were, the judge had to instruct them, look, if you convict him of PFO, this is the sentence range. This is what you have to do. So they had to go back. And I remember talking to one of the members on the jury after that. And they said, Daniel, we didn't want, we didn't like what he did. We wanted to convict him, but, we didn't know that. And that's unfortunate. The jury doesn't really get to know the parole eligibilities and the sentencing and things like that, especially with PFO. So just if you're out there, try not to catch felonies. And if you do, expunge them. I'll do a series on expungements and what you need to do. But I was doing Livingston docket for a long time, and for about a year and a half, and about half of them, just like, why don't you just, you could have expunged this, and now you can't, you can't get a diversion now. You're here with a firearm. You could have expunged this, and you could have possessed a firearm. Just go get pay the $250 and have it expunged, or pay the lawyer the $1,000 or $1,500 and get it expunged. Don't be lazy. Get it done, because it frees up your life. If you're caught with your buddy and a handgun's in the car, you don't have to worry about going to prison for 10 years. I mean, just get it expunged. There's no reason not to. So I'll do a video on that and kind of tell you all what you need to do. And certainly I would on that advise to hire a lawyer, but there are some of those things you can kind of do yourself. So hope you all have a good night. And so I guess next time we'll talk about expungements and the two statutes that control. And actually there's a third one most people don't know about, and I'll bring that up, and that'll help a lot of you that have maybe 2 felonies. You can get expunged that you didn't know you could. So y'all have a good night.